It's letting me record. That's awesome. Thank you so much for your help. Thank you. Bye. Oh, we're in. Woot, woot. Oh, my word. Okay. Well, now that we've got that sorted out, hi to all the folks at home. We've had a glorious 2 minutes of kind of catching up and then about 13 minutes worth of trying to work out what to do with TASAC. But we're all up to speed now and I'm the host and we're recording, so that's good. We have decided to start our drop-in sessions, and what I would like to do with these drop-in sessions is go through the week's content to try and, you know, get everyone on the same page, so to speak, as far as first principles concerned, so that then when it hits 6 to 7, we can unpack the tutorial problem in perhaps a more leisurely fashion than we were previously. So looking at what we've covered for this past week, we are now up to week 5, so we're dealing with illegality. This is the last of our vitiating factors before we start on basically the second half of the unit. And that's kind of what I was building up to in my comments before we started the recording. The way that the unit kind of ebbs and flows is we do the vitiating factors in the first half, and then from week 6 pretty much onwards, we roll downhill and we look at all of the various different ways that you can discharge a contract in great detail. And then finally at the very end, we look at remedies, okay? So the focus for the first half up to today is vitiating factors, and today is our last set of vitiating factors. So we've already, in our first assessment piece, obviously we're looking at mistake in a fair amount of detail. In the second assessment piece, typically, I haven't even drafted it as of yet, but typically it involves a vitiating factor, and it involves, you know, things like discharge and so forth, which we're moving into. So that's where we're at and where things fit in. In terms of illegality, what I might do is just share my screen now here. All right, let's get a Word document up here, and we can start our excursion on illegality. How did you find the readings for this week? Can I just get some feedback first? Confusing?
I've not yet finished, to be completely honest.
Yep, that's fair enough because it's assignment week, so I kind of expected that. We'll do some assignment troubleshooting after the you know, the main tutorial 6 to 7. I'm happy to stay back and do some assignment troubleshooting if that's what folks need. I'm aware that there are, you know, other stresses and pressures going on, so that's all good. Is there anyone that has, can I just see in the chat, who has had a chance to do the readings? So Melody's a no, Danielle yes, Carlo no, Daniel no, Jade no. Okay, so I don't really think that there's much point us sitting around discussing illegality if there's, if the bulk of us haven't had a chance to do the readings. Danielle, I understand you have, and Vivian, you have. What I might suggest is that we throw it open and we do a bit of a cook's tour then of the vitiating factors so far. And do you have lingering questions about the earlier vitiating factors? In particular, I'm thinking of misrepresentation, because that was an enormous week. And I feel like that misrepresentation tutorial, it's not bad in that it does, that problem with Rocco and Maria, where she's, I think that's the one that we have, isn't it? Let's open that one. Misrepresentation. I think that's the one with Rocco and Maria. Yes, it is. So that one, we went through the elements of fraudulent misrepresentation, but we didn't really get a chance to discuss the ACL. And I actually would really, if you guys don't mind, I know that it's a bit of a left turn, but give me some feedback. If you want to push on and talk about illegality, that's fine, but it's just going to be like a mini lecture, so it's probably not much point. I would have thought it might be more beneficial for us to spend this, say, half hour talk troubleshooting on things that you've had a look at, in earlier weeks where you have done your work and you've kind of thought, oh, does that make any sense? Or you've had some lingering questions. Before we do that, Vivian and Danielle, you have done your work on this week. So do you mind if we just talk about the principles of illegality when we do the main tutorial 6 to 7? Is that all right by you guys? Okay. So they seem to be okay with that. The thing that I really wanted to, I guess, explore with you, and this is really actually kind of nice for me because I do feel that the lack of a problem around misleading or deceptive conduct is a bit of a, it's a bit of a lacuna in this unit, and it would be good to discuss it. So I did post up a, I don't know whether you've downloaded it or not. I think you're still looking at my screen, aren't you? So it would be really nice if we could look at misleading or deceptive conduct. Now here, key concepts misrep. Where's my thought food? Here. Video. All right. Okay. So here's my thought food for misleading or deceptive conduct. So if you look back at the facts of our week 2 misrep problem, there is an immediate difficulty for Rocco in trying to use Section 18. Now, what I will preface all of this discussion with, and the reason why I'm actually quite happy that we get to spend a leisurely few minutes talking about misleading or deceptive conduct, is that in practice, you will almost never run a case of misrepresentation unless you are forced into it by the facts that you're given by your client. So unless there is no way that you can fit your scenario into Section 18, that's the only time you're going to be looking at the common law of misrepresentation, because it's just so craggy and relatively unfriendly. So Section 18 really will be your go-to provision whenever you get misleading conduct. But the problem with Section 18, and this is why I asked this question first, what's the immediate difficulty for Rocco in trying to sue under Section 18?
Oh,
Let's have a wee look here at, competition and, there we go. Oh, back here, Schedule 2. Okay, so misleading or deceptive conduct. Here's your magical provision. So when we're looking at a problem like Rocco and Maria, where she has misrepresented to him what she wanted to have that loan for, remember? She said that she had some kind of drug lord that she had to use money to pay off, otherwise they were going to burn her house down, remember?
yes.
So what hits you in the face, first off, about this provision, the difficulty of trying to make this provision work for you? Do you want me to just make it a little bit bigger?
Well, it's trade or commerce.
Is that better? Yes. Yes. And that's the really big limiting factor, isn't it? So it doesn't catch all of that private conduct that goes on between individuals. So
how would you get restitution? Would you have to go to court, a tort?
well, the only difficulty is that you just can't use Section 18. So you would have to, in those kinds of circumstances, you're forced back into the common law of misrepresentation with all its nooks and crannies and, you know, its limitation of remedies. Because remember, your main remedy for misrepresentation at common law is going to be rescission. But in a case like that, really, does rescission really help Rocco? I'm not sure that it really does. If she's gone off and spent money, the rescission's not going to really help much, is it?
You could always take a kidney.
You can try. Sorry? What was that?
I was being smart. He could always take a kidney and sell them in the open market.
Yeah, so limitations in relation to the common law action are fairly significant. I mean, you can rescind and then try and get the court to give you some kind of restitutio, but if she's penniless and she's got these goods, it's going to be a bit of a nightmare, isn't it, really, to try and commence an action like that. And in all practicality, when you're thinking about the fact that any very, very, very simple court case will cost your client minimum of about $150,000, it really puts an action, legal action for that kind of conduct between Rocco and Maria, it puts it out of most people's reach, doesn't it? But misleading or deceptive conduct is just such a magical provision because if you don't have the problem that Rocco had, so if it's not private conduct, the other big private conduct that it doesn't catch is, and where we find a lot of problems is people privately selling their home, their residential home. And because it's not in trade or commerce, it falls outside of this provision. And that's where it, you know, you might find that the amount of money that's at stake might make it worthwhile running an actual case of common law misrepresentation. But if you are lucky enough to have a client where the conduct has occurred in trade or commerce, this is just such a great provision. It is fabulous. The other thing I want to draw your attention to is that very first limb, a person. So I want to make sure that your understanding of the way that this provision works is sound, okay? So can somebody tell me what is the way that the legislation is set up between the Commonwealth and the states and how it kind of works together? If you cast your mind back.
Is it that the states have mirror legislation?
Yes. And why do they need to have that mirroring legislation?
To afford continuity?
Yes. Can you unpack that a little bit more?
Ooh.
It has something to do with the Commonwealth's very limited bank of statutory legislative powers.
Okay, so is that constitutional?
Yes.
As in Section 51, would that be?
Yes, absolutely.
Okay.
Absolutely. So the goal was that the legislation was enacted under Section 51 sub 20, wasn't it? And that is the corporation's power. Constitution of Australia. So if we go to the Constitution and we have a look, oh, how leisurely is this? It's lovely. Section 5120. So here we go. Oh, sorry, I've skipped down. The Parliament shall, subject to this Constitution, have power to make laws for the peace, order and good government of the Commonwealth with respect to. So, for those lovely people that have done stat interp, what does that mean, that introductory snippet there? Is this an exhaustive or inclusive provision?
Inclusive?
It is exhaustive.
Oh, that's exhaustive. Okay.
Yes, yeah, because it doesn't say something like with respect to such things including or including without limitation the following. That would be an inclusive provision. So it doesn't mean, an inclusive provision means all of the enumerated paragraphs that follow are just examples of whatever is introduced in that very beginning section, right? It's not limiting the breadth of the provision. It's just giving you little examples of how that might operate, okay? That's an inclusive provision. An exhaustive provision means that this is all you've got, okay? So these enumerated paragraphs are the only heads of power that the Commonwealth has to legislate. So it's the way that it's set up is that the Commonwealth just has these, I call them clause, not C-L-A-U-S-E, bad contract pun, but clause as in talons that drill down and bite into subject matter. And the only subject matter that the Commonwealth can legislate on is these that are in these provisions here. Okay, why is that? Because the states and state jurisdictions came first. And then we had the Federation imposed on it, didn't we? If you recall back to intro. And the states were very jealous about their legislative powers. And they are the ones that have basically limitless legislative powers as long as the subject matter has a sufficient nexus with their jurisdiction. They can legislate on pretty much anything they want. But when we had federation laid over the top of that, they were very careful to say, these are the only things that we want Commonwealth to have legislative power over. We don't want to give away too much of our power. Because if you do recall, what happens when you get a Commonwealth Act and a State Act butting heads, it's the Commonwealth Act that will usually prevail. So the states didn't want the Commonwealth running roughshod over their acts of Parliament, okay? They wanted to keep it constrained within limits. So these are the only heads of power that the Commonwealth has. Super important. And so you didn't know you'd get a bit of constitutional law this evening, did you? So the big one here for us, financial corporations formed within the limits of the Commonwealth. Okay, so when good old Section 52 of the Trade Practices Act was originally drafted, which then morphed in 2010 to Section 18, when that was originally drafted and the word person was used, that really only meant, as far as the Commonwealth legislation was concerned, it really only meant corporate persons, a company, because that was their limits, the limits of their power. This legislation was drafted on the basis of Section 51 sub 20. It can only bite on individuals' behaviour where that behaviour falls within one of these other heads of power. So things like if the conduct occurred by post, over the phone, on the internet, these services are all controlled by the Commonwealth. So where you see the word person, the conduct can extend even in the Commonwealth realm. The Commonwealth legislation can extend to a natural person if what that natural person is doing is caught by one of these other heads of power. Does that make sense? Yep. So there's your other immediate restriction. Another one where persons are often caught are interstate and there we go. Oh, there we go. Oh, that's not it. It's trade between states. Railway construction. It's here. I just can't see it at the moment, but it's trade between states. Oh, here. Trade and commerce with other countries and among the states. So if a natural person is doing interstate trade, that's another really big one where the Commonwealth legislation can bite onto a natural person's conduct. So when you say we needed that mirroring legislation in terms of the states, we absolutely did, because there was all that conduct by individual persons that would otherwise slip through the cracks. Yes? Hi, Kath. Nice of you to join us. Oh, Melody's saying something. We had our family business club. Oh, yes. The cost of running a legal case is hideous. It cost me well over $200,000. I've been on the wrong end of it, and believe me, it's not fun. So they're the two principal issues that you need to be thinking about when you're thinking about misleading or deceptive conduct. And whenever you come up against a problem scenario in terms of misleading conduct, as I said, I haven't drafted the second assignment, but often it involves using Section 18 just because I think you guys need some practice in working with Section 18. They're 2 points that you really do need to bear in mind. It might sound rather arcane, but you need to know how the legislation fits together in terms of what the Commonwealth legislation can cover and what the state legislation can cover. And that big limitation about trade or commerce. Can anybody recall, and 10 brownie points if you can, the case that talks about what trade or commerce is? Can anybody remember that one? It was the Concrete Constructions case. Concrete Constructions in Nelson. And that case was quite useful because what it involved was some discussions that had gone on between a foreman and a worker. And the foreman gave the worker instructions on how to carry out a job, which the worker did, but the instructions were incorrect and the worker got injured. And so the worker sued the foreman to try and claim some compensation for their injury. And the question here was the instructions by the foreman in trade or commerce? In trade or commerce. What does your gut tell you about that set of circumstances? Should that be in trade? When someone just passes on instructions on how a job has to be done? Is that in trade? Is it like a real estate agent selling a house by an advertisement and placing incorrect information in there? What does your gut tell you?
Yeah, maybe.
You think? Does anyone have another view? No? Don't know. Kath's reading everyone's mind. In that case, it was held no. It was just internal instructions. There wasn't that same element of commerce. I was kind of likening that scenario to the real estate agent to try and prompt you by thinking about what it is that makes something in trade. And usually it has that commercial flavor. The representation will have some kind of commercial flavor to it. Do you know what I mean? Buying, selling, profits, you know, the hustle and bustle of business. And this was just a foreman passing on, you know, and instructions to Joe Blow, go and do it this way. Do you understand? Does that make kind of intuitive sense? Yeah. So internal company communications like that, really not in trade or commerce. You're looking for something that has that buying, selling, commercial flavour to it. And that's usually where, you know, the representation will be ripe for a Section 18 cause of action. Engaging in conduct. This is another lovely one. And here I particularly like the fact that we don't have the same problems that we do. Remember in the common law of misrepresentation, you have all of those rules around silence, and silence generally will not be an actionable misrepresentation unless it fits into one of those exceptions. Remember the exceptions? So if there's some kind of half-truth, or if there's a duty to correct where the information becomes untrue, or if there's a duty to the person. Remember all those exceptions? So here, the beauty of it is if you flip up to the the definitions here, in this schedule, a reference to engaging in conduct is a reference to doing or refusing to do any act. Refusing to do any act, including the making or giving of effect, and then look down here, a reference to here. Otherwise than inadvertently. Here, a reference to refusing to do an act includes a reference to refraining otherwise than inadvertently from doing the act, i.e. deliberate silence. If you have refrained from speaking up, otherwise than inadvertently. So if you've just forgotten to speak up, then it's not going to be conduct, engaging in conduct, if you've just forgotten to speak up. But if you have otherwise than inadvertently, so if you've deliberately refrained from doing an act, i.e. speaking up, that is squarely within the notion of engaging in conduct. Does that make sense? So here, it's a very stark contrast to the common law, isn't it? Because at the common law, it basically says you're on your own. As far as silence is concerned, it's not going to be actionable unless you can squeeze your facts within one of those exceptions. Yes? Here, on the other hand, beautiful, we've got basically any deliberate silence will constitute conduct that is squarely within Section 18. The other thing in terms of conduct, and I will take you to this as well. This is why I love actually just mucking around in the legislation, because, you know, nothing can substitute actually going to the Act and reading it. But look at this. Remember all of the shenanigans that you had to hop around on in terms of giving opinions at common law and predictions? Here we have an amazing provision. Amazing. And when I've finished explaining it, your hair will stand on end. Let's
I
just
don't have any hair.
Well, if you did, it would be standing on end. So, misleading representations with respect to future matters. If a person makes representation with respect to any future matter, including actually doing something or staying silent, and the person doesn't have reasonable grounds for making the representation, get this, the representation is taken to be misleading. What does that mean? What does that mean?
Does it mean that if you're going to do something, or you know something may happen in the future to, I don't know, affect the situation in some way, that because you're saying, refusing to do it, like you're not saying anything, or maybe refusing to say anything, then you're misleading that.
Yep, if you don't, that's exactly right. Sorry, I think I cut your end bit off there, Kathleen. Keep going if there was something further. This is an evidentiary provision. And if anyone is making any representation about a future matter, they had better have very good grounds for making any representation like that. Because if they do not have reasonable grounds, they have automatically breached Section 18.
Just before, like, you know, like a warranty on a car, these days they're like 7-10 year warranties.
Yes.
Sort of, maybe, I don't know.
There is a case where I see what you're searching for, Carlo, is an example of this kind of thing happening. The one that comes to mind is where a couple went to a bank, and the bank made representations to them about the interest rate they'd be getting in the future. Now, that kind of a scenario is the precise scenario where this kind of thing can crop up. So,
could that happen in something like shares? So if I was to say to someone, buy these shares because they're going to go up in the future, I guarantee that they'll go up.
Yep.
And then they don't.
Yeah.
Obviously, something happens and it all falls apart. Would that be the same type of thing?
Yeah. You've got to have reasonable grounds. Now, this is how it all plays out. What happens is the overall burden of proof for Section 18 lies on the plaintiff. So the plaintiff has to actually go ahead and satisfy Section 18. So when you're looking at Section 18, a person must not in trade or commerce engage in conduct that is misleading or deceptive, right? So the overall burden of proof for proving those liens is on the plaintiff. However, if the plaintiff is complaining about a future matter like this, they have the benefit of what is effectively a presumption. Unless the defendant can show the court reasonable grounds, then that representation will be taken to be misleading. Now, what happens then if the defendant can show some evidence, some kind of grounds that they had on which they based their prediction about the future matter? The way it works is this. So, where are we? Here. All that happens is the court takes into evidence the defendant's stated reasonable grounds, and the court considers whether they think those grounds are reasonable, okay? Now, if the defendant can convince the court that they have reasonable grounds, that doesn't get them off the hook straight away. All it means is that that presumption won't apply and they won't automatically be taken to be misleading, okay? What happens then is the plaintiff has to go on and then prove that, notwithstanding whatever grounds there were, overall the conduct was still misleading or deceptive or likely to mislead or deceive, okay? So to avoid doubt, because there was a whole, this provision's been amended so many times, it's like a piece of Swiss cheese. And there was a whole lot of squabbling that went on because, particularly in civil matters, the plaintiff always has to have the onus of proof. It's not on the defendant to prove themselves innocent. It's for the plaintiff to prove the contravention, yes? So there were people who were up in arms and saying, oh my goodness, you've reversed the onus of proof and now you're making the poor old defendant prove the fact that they didn't contravene the legislation. So what they've done is they've said to avoid any doubt, this presumption doesn't have the effect that merely because the defendant's evidence gets put into court, the person who made the representation is taken to have reasonable grounds. So all they do is they put that evidence in and the court decides if they think they had reasonable grounds, okay? And it doesn't have the effect of placing on any person an onus of proving that whoever made the representation, had reasonable grounds. So it doesn't reverse that onus. It just means to get themselves out of that presumptive predicament, the defendant has to show the court, I wasn't just sprouting hot air in relation to this future matter. I actually had some basis. So how about that? And the other thing that I want to, and this part we will unpack ad nauseum in week 10, but the thing that I really just want, and I know it's 6:01, so I'll make it super duper 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 quick, but this is exciting, folks. Well, it is to me. So here, where are we? 236. 236 is your good old damages. So you can get damages, obviously, for a breach of Section 18. Where are we? There we go. 232 is injunctions. 236 is good old damages. But this is the really funky cool provision here. Ancillary orders. A court may, on application of a person, if you're going to suffer loss or damage because of a contravention of Section 18, the court can make such order or orders as the court thinks appropriate. Wow. The court can basically tailor the remedy for the exact situation. I know, Kathleen. The court, this is a legislative blank check. The court can basically order whatever they need to order to fix things. And it says here, for examples, and here, Kurt, have a look. This is your typical inclusive provision, right? If you flip down, it says if you want examples, have a look at 243. So you flip down to 243. Oh, my word, kinds of orders that may be made. See here, without limiting Section 237. That's your classic introduction for an inclusive provision. The kinds of orders that a court may make are all of this stuff: an order declaring whole or any part of a contract to be void only after a particular date, varying a contract or being varied from a particular date, refusing to enforce, directing the returns of money. I know, right, Kathleen? This is amazing. An order directing the respondent to supply specified services. Go and have a look at 243. It's kind of this magical Christmas wonderland of stuff that you can get. So
Yes,
this is why I say, I'm sorry to harp on about it, but this provision is just awesome. Sorry, I'll stop ranting now.
Yes, but the judges, wouldn't they go through old cases or maybe look for a rough idea, or would they just make things up?
Generally speaking, the plaintiff will ask for what they want.
Okay, that's what I thought. Yeah.
And then the court will work out, well, you know, we can do that, but we can't do that. Do you know what I mean? Mm. Yay! That was kind of fun. Well, it was kind of fun for me anyway. And that's the main thing. Anyway, let us, without further ado, I'm still recording. Yay, and it hasn't told me I have 3 minutes. I am going to skip back. Hello to all of the people that have joined us for our 6 to 7.